Honorable Court of Appeals of Tennessee is now in session. God save the state of Tennessee, the United States, and this honorable court. You may be seated.
Good morning. I have a cord there, and I was just trying to figure out what it was. We all had a beautiful day to drive in. It was gorgeous, as opposed to the last few days. So better for that. Call the case, please.
Tina Marie Eltzroth versus Danny Ray Eltzroth.
We'll hear from the appellant.
May it please the court, I'm Felicia White, and I represent the appellant, Tina Eltzroth. And I would like to reserve 5 minutes for rebuttal if needed.
That'll be fine.
This case today centers around a default judgment that was granted in a divorce. The divorce was filed by the wife, the appellant, and the husband, the appellee, was properly served with that complaint for divorce. When the husband failed to file an answer within that 30 days, the wife then filed for a default judgment. The husband failed to appear at that hearing, and that default was in fact granted. Over 9 months later, the husband filed a motion to set aside that default under Tennessee Rules of Procedure 60.02. In that motion, the husband, though, failed to allege any facts that would justify his failure to file that answer within that 30 days. However, at the hearing on that motion to set aside, husband filed an affidavit where he actually alleged that he had not been served with the complaint for divorce. The testimony at the hearing, though, proved that he had in fact been served with the complaint for the divorce, and the court made that specific finding. After the proof concluded, the court found that the husband's misunderstanding regarding being served was drug-fueled, and that was the court's own words, that it was drug-fueled. He went on to say that that fact was very, very clear to the court. And he further found that "I may not remember being served" was not an excuse. Then the court went through the factors that they should consider when determining whether a default should be set aside under Rule 60. The first of those factors is whether the default was willful. I would submit to the court that when the trial court found that the husband had been properly served and that his confusion or misunderstandings regarding being served was due to his drug use, that is a finding that the default was willful. However, it seems from
Was that finding as to service of the complaint or service of notice of the default?
That was regarding his misunderstanding regarding being served.
Served with the complaint?
With the complaint.
With the complaint, not the
yes.
notice of, not any notice of default?
Correct,
Okay.
with the initial complaint.
All right.
When the court, though, was ruling on that factor, it seems that the court mistakenly was looking at the actions of the wife in determining whether that default was willful. The court actually said, well, in the sense that it was the intent, of course, to take the default. Well, of course it was the wife's intent to take the default, but the court should have been viewing or reviewing the actions of the defaulting party rather than the non-defaulting party in that. So regarding the first factor of willfulness, it's our position that, first of all, that the court erred in viewing the actions of the wife, the non-defaulting party, rather than the husband, and in not finding that his actions resulting in the default were willful, in light of the fact that the court found that his misunderstandings regarding being served with a complaint were drug-fueled, which clearly was willful. If the court made the finding that the default was willful, then the inquiry should have ended there, which is our position. However, in looking at the second factor, which is whether the defaulting party had a meritorious defense, I would submit to you that the court also erred in finding that that factor did not also weigh in favor of the wife, as the husband failed in any way to properly set forth a meritorious defense as he was required to do. He was required to file pleadings, a motion, a petition, or an affidavit that set out that he had a meritorious defense and what that defense was.
Well, the trial court found, didn't it, that there are issues pertaining to the disposition of the property. Based on the testimony the court has heard today, there would be some dispute, some reasonable disagreement about the allocation of the ownership, the payment of the debt. I mean, the trial court found that, correct?
Yes.
Okay.
I think that it would be our position, or our position is more along the lines of that, based on case law, that the husband had a duty to allege that he had a meritorious defense and what his meritorious defense was in the pleadings that he filed under Rule 60. That his motion, he just made the statement that he did not believe that the division of property was fair and equitable. In his affidavit, he said the same thing, that the division of the property was not fair and equitable, and then went on to say that the parenting plan was not in the best interest of the child.
So you think he should have said more specifically I should have received a certain amount of the value of the marital home, and or I should have received some parenting time? He needed to lay that out.
Correct. I believe that the case law requires that he set out what his meritorious defense is, rather than just making a conclusory statement of it's just not fair. And the last factor, which is probably the least, I think, relevant in our case, was the prejudice to the non-defaulting party. As I pointed out in my brief, the husband actually stipulated at trial that the wife would be prejudiced if the court set aside the default. His attorney actually argued, well, Judge, we can just stipulate that she would be prejudiced because she got 365 days, all the support she wanted. I don't see how she could not be. But even with that stipulation by the husband, the court found that the wife would not be prejudiced by depriving her of 100% of the property, and that her statements regarding the care of the child, while it was important to the court, that it really didn't pertain to what we were doing there that day.
Well, but is that really the kind of prejudice that the cases talk about? I mean, obviously, whoever got the default judgment would always be prejudiced to that extent that you won and now you haven't won. We have to find out. So, I mean, it's obviously detrimental to them. It's a prejudice to whoever who got the default, but that's not really what it's talking about, is it?
Well,
Otherwise, there would always be a prejudice.
Sure, yes. But it was our position that because of the length of time, I mean, again, it had been 9 months that had gone by from the default and the husband even filing the motion to set aside. By the time that we had our hearing, I believe it was 14 months later. And it was our position in court that when the court then sets this aside, it's setting aside this parenting plan, which had awarded the mother with, or I guess awarded the husband-father with only supervised time with the child, and had kept him from having access to that home. So by then setting that aside, he would have just free reign to come back into the home and to then be back around that child until we could obviously then get into court. And you know, just with the way that the legal system is, I mean, while we could have immediately filed a motion for something to have been heard, he would have had free access to that child after this 14-month period of not being around the child at all. When we attempted to argue about the prejudice regarding that parenting plan, that's when the court ruled that while the parenting issues were a concern to the court that it wasn't something that he believed that we were dealing with that day. So he did not believe that there would be any prejudice in setting aside that default regarding that parenting plan.
Let me ask you, counsel, do you agree in our review of this, we're looking at abuse of discretion standard? Okay, explain to us, if you would, how what the trial court did rises to a level of an abuse of discretion.
Well, I think that mostly goes back to my first point under the willfulness. That, first of all, that I believe that the court got the law wrong in viewing the actions of the wife rather than the actions of the husband. By the court finding that it was willful because the wife intended to take the default, I mean, that was an error. I mean, he was clearly looking at the actions of the wife. But even looking at the facts, by the court finding that it was drug-fueled, that his actions were drug-fueled or his default was drug-fueled, that he should have made that finding that his actions were willful. And so he failed on that first, I guess the first factor. And that's all the time I have.
Okay, thank you. You have your time for rebuttal. Hear from the appellee.
It's a pleasure to be here today for this honorable court. Your Honors, all the facts in this case matter. I think starting out to understand the context and the way Judge Ogle ruled with regards to Mr. Eltzroth in this case and deciding to set this matter aside, the court took a lot of things into consideration. I think the first part was that the court realized and recognized that from the beginning these parties were acting pro se, trying to agree and pass papers back and forth printed from online to try to agree on this divorce and with these kids and this marital property. And this had gone on for a period of time. And then right up until Ms. Eltzroth hired Ms. White, and Ms. White's assistant went out to and found Mr. Eltzroth at the marital home. He had been gone. He'd been living in Nashville. He had a substance abuse problem. Thought of his sister, Miss Taffer, who was mentioned in my brief several times. It's a lot like it's his big sister. She takes care of him, everything he really does. He just runs it by her. So she helped him get out of town, away from the issues that he had and the people he was running around with, and got him into Nashville to try to get him into rehab and get him straightened out. So he was traveling back and forth during this period of time. So once Ms. Eltzroth realized that he was at the marital home, she contacted, I'm guessing, Ms. White's office. Ms. White sent a paralegal out and had Mr. Eltzroth served. I think there was some confusion. There's no doubt he was served. I mean, the court recognizes that. Judge Ogle recognizes that, yeah, you know, you were served. There's a witness and testimony today. I'm going to accept the fact that you were served. What Mr. Eltzroth never, admits or never understands or confesses that he understood that he was served. But I think lawfully that he was, and the court recognized that. So moving on down to what I feel the main issue was the notice of default. And I think that's where Judge Ogle really felt and dug in and kind of hung his hat on, was the fact not necessarily that he wasn't served with a divorce complaint, that he was. Our position has always been that he just didn't recognize that. But when it comes to the notice of default was sent to the marital residence. Ms. Eltzroth this entire time knew that he was back and forth, had been in contact with Ms. Taffer, and in fact knew where he was. And there's proof of that because she had contacted the child support office on or before the notice of default was sent and gave the child support office the Nashville address, but yet failed to notify her counsel that where the defendant or where Mr. Eltzroth actually was. So the notice
Well, it was kind of here and there and everywhere, though, wasn't he?
He was.
He didn't really have a set place that he was living. Is that fair?
He lived a bit of a nomadic lifestyle, to say, and that is very fair, Your Honor. But nevertheless, I think she had a duty to notify her counsel that if he was here, there, and everywhere, let's send the notice here, there, and everywhere. because I think that that's the responsibility of a party. And I think that her unwillingness to provide that information to council just feels a little off with regards to that.
But didn't the record show that she knew he was going to be there over Thanksgiving, over that week?
Yeah, there was a point in time, Your Honor, that she knew that he was going to come into town. I can't remember the exact date. It may have been Christmas or Thanksgiving. It may have been Christmas. It was a holiday.
Yeah, it was a holiday. And then he'd be there that week, was going to be there that week. But that doesn't
For
necessarily...
court of some undetermined type.
Yeah, he couldn't exactly recall exactly what he had court for. I think he was referring to maybe to a criminal case he may have had. So, and Judge Ogle had to question him about that, and I think we got that ironed out.
That wasn't particularly clear from him, was it?
No, it wasn't clear. But I think, something else that's important, just to go to Ms. Eltzroth's intent, there was a line of questioning that I had referenced on page 9 of my memorandum to the court. I asked her, I said, so it's fair to say you would have done whatever it took to make sure this man is outside of your kids' lives and and she said, at this point, yes. So from that point forward, I really tried to hone in on the fact that she would have done anything to keep him out of her children's lives. And of course, I can understand that as a parent, especially if there's a spouse has a substance abuse problem, you want to protect your kids and do what you can do. But at the end of the day, if that resulted in my client's, if that resulted in a situation where he could have received notice at a different location, I think that's something that I would ask the court to just pay particular attention to, and I'm sure will do so.
Counsel, let me ask you to address, excuse me, Ms. White's argument as to what the trial court did or didn't do as far as willfulness. Why don't you go ahead and talk about that and make sure we get that in?
I'm sorry, can you ask that one more time? I'm so sorry.
Her argument that the trial court put the willfulness burden on your client, on her client, as opposed to being on your client to show that his actions were not willful.
Okay, thank you for the question. And I think that goes back to, just the context and the factual situation as a whole. You start out with them negotiating as pro se litigants. Counsel's retained. He's served. Really doesn't know what's going on there. His position is, but he was. Then you move on down to the default portion. I don't know that the court really laid the blame on Ms. White's client with regards to the willfulness.
Well, did the trial court
aspect.
find that your client's actions were not willful and resulting in the default?
I think the trial court found that the court ruled that the question of notice of default, of him actually having actual notice of the default, is unclear to the court. For those reasons, based upon proof of the record, and there's disparity in the proof on certain issue, the court thinks the petitioner in this case, the movement, has established a case for relief under 60.02. So I think the court was really taking into consideration the fact that the court couldn't find a clear path to whether or not notice was properly given to Mr. Eltzroth. So I don't know that it really goes so much to willfulness. Sorry, pull the statute.
Well, the only, unless we missed it, the only thing we saw what the trial court said was whether the default was willful, period. Well, in the sense that it was the intent, of course, to take a default, obviously. So I don't recall seeing anywhere else where the trial court talked about willfulness as as applied to your client's action.
And thank you for reminding me that I do recall that those words. And I think when the trial court ruled, I think he was taking into consideration that because of his transient nature, and because notice was sent to one place, that it wasn't willful. It wasn't willful conduct on my client's behalf to not appear and argue and respond and answer that divorce complaint. In fact, one thing I think is important, even after this default judgment went down, he retained counsel. He actually retained an associate in my office to file a complaint for divorce, almost a good period of time after this default judgment. So either two things. One, my client's very calculated and smart, trying to cover his tracks, or B, he really didn't know and hadn't disclosed that to his family either, because they were a part of helping him retain counsel as well. In fact, Ms. Taffer, I think, is an important witness here as well, because everything Mr. Eltzroth did, he run it by her. I mean, she's the big sister, looks out for him, and she testified that she was unaware of any sort of default that he had gotten. In fact, she was never even told that he was served with a complaint for divorce. Of course, we know the court's ruled that, hey, look, he was served, but of course, the client's position is, I never knew it. But he never disclosed that to her either, and that was her testimony that she was unaware as well. So that's corroborating testimony to that point, in my opinion. So, and prejudice, kind of want to hit that just for a moment. There's case law that talks about that time isn't necessarily a direct evidence of prejudice. Ms. Eltzroth testified that she's been in a marital home, she's staying there. So I don't think she's going to be put in any sort of prejudicial harm by the court, by this court affirming the trial court's opinion. And with that, Your Honors, that's all I have. I'll be happy to answer any more questions that you may have.
I hear none. Thank you.
Thank you, sir.
We'll hear from the appellant and rebuttal.
I don't really have anything else for rebuttal based on that, unless the court has any additional questions.
I hear none.
Thank you.
Thank you. The court appreciate your arguments and your briefs on this matter. Enjoy it as you head back towards the mountains.
Yeah, I appreciate the court, and let y'all know, I appreciate all of you. And I mentioned it to that clerk, working with my schedule, and then got back up to Nashville. I rode about 5 hours of rain trying to get home last night.
Yeah.
Preparing to
Well, I sat in Nashville last week, and it was a simple 5.5-hour drive back because there were 3 accidents on the way.
That's 12 years of my drive, I think, increased by about an hour.
Yeah, I can believe that. Well, I will tell you that I wasn't aware there was a statute applying to the courts helping work with members of the General Assembly. I didn't know it was there. I'd never had it come up.
And I just, and I appreciate it, and I thank the court for acknowledging that.
Well, but that's fine. We're very cognizant of the fact that the parties, not so much the lawyers, but the parties in this lawsuit, as in most every lawsuit, are kind of stuck in limbo land until they get a resolution one way or the other. It wasn't uncommon when I was practicing law to have clients tell me, I just want to know. Everything's done. We've had, trial. Judge took it under advisement. I just want to know now, so what we can do. So, but in any event, we appreciate you all being here this morning. So thank you very much. Adjourn court to our next regularly scheduled docket.
This honorable court is now adjourned until our next session. Thank you.
Thank you.